Hello everyone, welcome you all to Believers as Academy. In today's topic of the day discussion, we will be understanding what contempt of court is. So, time and again, we have seen the usage of the word contempt of court alongside some derogatory statements made against the Chief Justice of India or probably the judiciary system of the country as a whole. Wherever we have seen such derogatory remarks or any unpleasant remarks that have been made on the judiciary system, the very next word that gets attested to it is the contempt of court. So we have time and again seen this word usage, especially when there is something controversial comments made by the politicians or the public figures, once again against, let's say, the Supreme Court or the High Court, or probably any judicial system of the country. And also, we tend to hear this particular term even when any particular social media post tries to scandalize the court's opinions, or let's say the court's proceedings. And also we also see this especially when non-compliance with any court orders also happen. Let's say court has given particular order and someone is trying to willfully disobey the particular orders given by the court, be it the High Court or the Supreme Court, right? Even then we come across this term called as contempt of court, even especially when media trials that may influence the ongoing cases. Let's say there's an ongoing case which is absolutely of utmost importance, but media tries to intervene now and then and talk about the proceedings, and it tries to influence the ongoing case even before the judgment has been given. And also we time and again see this particular instance, especially during debates on free speech versus judicial authority, as in we have Article 19 where we have the right of freedom of speech and expression, right? But also at the same time, does that not allow you to condemn the judiciary or the judicial authority even when they are doing something wrong, right? So these kind of debates are something that we constantly see, especially when we have to study about contempt of court. So, what is the context as to why we are currently looking at it? Is because of the recent issue which surfaced with respect to the Chief Justice of India, where few derogatory remarks were made against him, triggering calls for the contempt proceedings. And even before we understand what is the issue, or let's say what are the major provisions with respect to contempt of court, we will understand in simple terms what exactly is contempt of court. So basically, there is no clear definition given in the constitution, because in the constitution, if you have to check, they have not at all mentioned in detail as to what contempt of court is. However, when studying the fundamental rights under Article 119, subclause 1, contempt of court is given as one of the reasonable restrictions, right? Because Article 19 gives the freedom of speech, expression, movement, and all of those things, right? Basically, it talks about the right of freedom of speech. So, this right to freedom of speech does not make sure, or does not mean that you can talk according to your whims and fancies with respect to the judiciary system. So, first and foremost, we have something related to contempt of court in Article 19, subclause 1. However, the Parliament passed this Contempt of Court Act 1971 based on the H.N. Sanyal committee recommendations to understand or to give an overall understanding about this particular issue, the contempt of court. So, what does the Contempt of Court Act 1971 has to talk about the contempt of court? So, it clearly delineates or clearly states that there are two different types of contempts. One is the civil contempt, which is very simple: when a particular individual or an authority willfully obeys, right? They are willfully disobeying the court orders, any judgments or undertaking. So, at that particular situations, we call it as civil contempt. And then, second is the criminal contempt. So, criminal contempt is when a particular individual or a particular authority or company which tries to deliberately scandalize or lower the authority of the court, maybe through their reports or maybe because they are giving an opinion in a news channel, or maybe because of some magazine that they have published, or probably they are talking about it in some digital platforms like YouTube or Instagram or any social media platform. So even that is also considered as criminal code. And not just that, even prejudices or prejudicing the judicial proceedings. Let's say even before the verdict is given, right? Even before the final verdict is given, let's say someone is talking about the particular judicial proceeding which is happening. Not just talking is fine, but talking in a very derogatory manner, right? So that is contempt of court. And also obstructing the administration of the justice, this is also pretty much considered to be as contempt of court. So if you see contempt of court, there are two important things. One is the civil contempt, where if a person or an authority willfully disobeys to follow the court orders or judgments or undertakings. Second is the criminal contempt, where through any means such as written or even through spoken, even published or digital contact, if any authority, if any person is trying to scandalize the authority of the court, or probably trying to prejudice the judicial proceedings, or even obstructing the administration of justice, it is considered to be as contempt of court. Now, talking about the constitutional provisions, as already we have discussed, it is mentioned under Article 19 subclause 1 as one of the important reasonable restrictions. However, Constitution separately talks about contempt of court in Article 129 and 250. So in 129 it says Supreme Court is a court of record and has power to punish contempt of court. And with respect to Article 215, High Courts are court of record, similar powers as vested in the Supreme Court. So basically these are those powers which are inherent and supported by the Contempt of Courts Act 1971, which means court themselves can uh, act upon any such contempts, on a suo moto basis, right, without even having to get a report, or say even without having to get a something in writing. Let's say it doesn't require a petition to be filed to act against a particular matter. Supreme Court and High Court has power by itself, and also it is clearly stating that Supreme Court and High Court is a court of record, which means whatever proceedings happen, whatever a particular High Court, let's say a Karnataka High Court has decided on a particular issue or given a particular judgment, so now that becomes the court of record and can be used as a testament, or can be used as a landmark judgment in itself for any further interpretations on the similar issues elsewhere in the country, right? So that is what court of record means. So these are all the two important provisions you have to keep in mind: Article 129 and Article 250. So now that we have understood what is contempt of court, also it is important to know what is not considered as contempt of court. See, we have right to speech, and right to speech with certain limitations is always acceptable and is also considered to be the fundamental right of a citizen. So hence fair and reasonable criticism of a judgment is totally acceptable, and criticisms based on facts, truth and public interest is also not considered as contempt of court. And even if, let's say, a particular person tries to report a court proceeding in a very bona fide, in a very good way, right, pleasant way, or with the real actual data or stats, so even that is also not considered as contempt of court. Also, in the end, we will also have to try and understand few important dimensions, because with respect to the contempt of court, the initiating contempt, the procedure, right? So the first important thing to keep in mind that court can start the proceeding on a suo moto basis, right? It doesn't require an additional petition to be filed or for to act upon it. And even in case if a third party petitions are to be filed, they have to take the prior recommendation or the prior consent of the Attorney General of India and the Advocate General of India consent. So Attorney General of India if it is with respect to Supreme Court, and Advocate General with respect to High Court. And for anyone who is accused or punished under or for the contempt of court, the punishment is up to 6 months simple imprisonment or 2,000 fine, and sometimes both can also be awarded. And this can even be dropped with a genuine apology as well. So this is also important. Also, we have to understand, try and learn few important landmark judgments with respect to contempt of court. One is with respect to what does not constitute the contempt of court. the fair criticism which is allowed, right? So this was allowed in Ashwini Kumar Ghosh case 1952. That is important. And can abusive comments or vulgar languages, abusive languages can be used when talking about a court proceeding, or probably talking about someone's judicial capacity or judicial authority. So that was pretty much a big issue. And in the MV Jayarajan case 2015, Supreme Court clearly stated that even using abusive comments, abusive language, derogatory language to defame the judicial authority is also considered as criminal contempt. So I think this is pretty much sufficient. In this particular video, we have understood what contempt of court is, civil contempt, criminal contempt, right? And we have also understood the constitutional provisions. We've discussed Article 129 and Article 215, both with respect to Supreme Court and High Court respectively. And also we have seen what is not considered as contempt of court, and pretty much we have even tried and analyzed all the important dimensions. So even before we end the video, let's solve one prelims question. Consider the following statements about contempt of court in India. Both Supreme Court and High Courts derive their contempt powers directly from the Constitution. Truth can be used as a valid defense in contempt cases. A private citizen can file contempt petition in Supreme Court without Attorney General's consent. So use your comment section, leave the answers below. Anyway, we'll meet in another video with another topic of the day. Until then, signing off, this is Madan Gopal. Have a wonderful day.